Hello, Steve Thatcher again from Help with Debt UK. This time I'm talking about living in Southern Ireland and going bankrupt in Northern Ireland. I'm getting an increasing number of calls and emails from people asking if they can remain living in Ireland and yet travel across the border in order to declare bankruptcy in Belfast. In reality, the short answer is no. If you're an Irish citizen and you wish to avail yourself of the Northern Irish bankruptcy laws, then the plain fact is that you must establish your centre of main interest in the province. This would be the same if you're moving to Liverpool to do the same thing. It doesn't matter that the reason you are moving from the south to the north is simply to go bankrupt. The fact that you have relocated gives you a legal right to declare bankruptcy using EU law in Belfast. So, for commie purposes, that centre of main interest purposes, you should ensure that you obtain a national insurance number. This enables you to look for work or work on a self-employed basis. It forms a mechanism by which you'll make contributions to the National Insurance Fund and hence latterly become entitled to benefits yourself. If you're living in Northern Ireland, you need to obtain accommodation. This should be at a reasonable rent and of a permanent or semi-permanent basis. A 6-month assured short-term tenancy would be ideal. With a place to live, you need a bank account. I have often recommended the Co-op, but also increasingly an account which costs a small fee to administer each month may also be easy to open. If you can, you could also see if you could obtain a Barclays account. With the bank account, you can register for utilities and indeed vice versa. With these items, you are laying the groundwork and showing that you have your centre of main interest in your new home in the north. Your bankruptcy petition asks where you have lived for the greater part of 6 months. You therefore need to be in the address which falls within the jurisdiction of your court for at least 3 months and a day before you even contemplate seeking a bankruptcy order. My firm advice to my clients now is that you should extend that time to at least 5 or 6 months. Many say that it must be 12 months to have lived in a jurisdiction. I have not seen any reason or explanation for these times. It may simply be that writers are churning out the same times without thought, just because somebody else has quoted it. There is often a proliferation of articles on this point on the internet. The fact that you have lived in the UK for less than 12 months can lead the official receiver to investigate whether or not you are really living in the address you say you are. Now that doesn't mean he will. If you have settled there and there is evidence that you are entitled to present your petition to the court, then the official receiver may take steps not to investigate you. However, you should be prepared to expect an investigation if you've moved from the south of Ireland to the north and been there for less than 12 months.